of the Western Cape Provincial Parliament. Today we are dealing with a follow-up briefing by the NCOP delegate as well as the Department of Basic Education on the Basic Education Laws Amendment Bill B2B 2022 NCOP. We will also continue our discussion on the public participation regarding the bill, just some feedback that we have for members from the NCOP, and then we have one set of draft minutes that our procedural officer have also sent us for us just to consider. Just for those watching online, you might be asking yourself, what is the difference between last week's meeting and this week's meeting on the respective bill? Last week, we dealt with overviews of the respective clauses and overview analysis of the respective clauses, and we thus requested the department to come and do the clause by clause on the bill, including what current legislation is being amended, how is it being amended, the reason and the impact for the respective amendment. I'm going to allow members just to introduce themselves, and then I'm going to allow the respective delegations to introduce themselves, and we will be jumping straight into the presentation, followed by questions and answers. My name is Deirdre Bartman. I'm chair of the committee.
Good morning, Chair. Good morning, everybody. My name is Christopher Fry. I'm a member of this committee.
Good morning, members. Good morning, Chair. Phil and Christians, member of this committee.
Morning. Yeah, I see another member online, member Bosman, but it says on hold, so you might be having technical. Other colleagues, I'm just going to mute everyone else and just also ask that everyone who's not on the floor just keep their mics muted, please. Okay, we can then continue with the respective delegation. Department of Basic Education, you may introduce your delegation.
Good morning. I am Liesl Karalison, the parliamentary liaison for the department. We are still waiting for Mr. James Ndlebe, who will be giving the presentation to join the meeting. Thank you.
Okay, we are at 3 minutes past 8. How long does he need still?
If you just give me a minute, I'm just checking with you.
Thank you. Mr. Honorable Bosman, your hand is up.
Morning, Chairperson. Sorry to interrupt. I just wanted to say that I'm also attending. I couldn't introduce myself earlier because I did not know how to work the microphone.
No problem. We have been switching between Zooms and MS Teams and Skypes and lots of different apps. We are easing in back to MS Team. Member Brankers, are you with us? I didn't hear you. Yeah, your purple bubble speak.
Yeah. Good morning, Chair. Good morning to all the members in the department. Khalil Brankers, alternative member for the Education Committee. Thank you, Chair.
Thank you so much. Ms. Karalison, if you could just please indicate how far you guys are. It is 5 minutes past 8, and the meeting has been specifically set up to deal with the clause by clause from DBE.
Okay, I am not getting hold of Mr. Ndlebe.
Okay. Ms. Hassan Musa, I'm going to take my discretion in terms of the WCPP rules to suspend the meeting for 5 minutes. We cannot be starting late on a meeting like this, firstly. We need to deal with the clause by clause, so please, if we could get the respective officials as soon as possible. We need to be able to deal with this clause by clause on the bill before we go out on public participation and before we submit the adverts on the bill. Otherwise, the members of the public are not going to know the content on which they may make submissions. Okay, we will continue at 8:10.
So noted, Chair.
Past 8. Ms. Ndlebe, I just want to check that you are online and able to hear us.
Loud and clear, Honorable Chair.
Wonderful. Mr. Ndlebe, it is 10 minutes past 8 and everyone have introduced themselves to the record. So I'm going to ask that we please just jump straight into the presentation.
Thank you very much, Honorable Chair. This is what the chairperson has requested, that we look at the old SASA, we look at what changes has been brought about, and we go through clause by clause. And the very first clause that we have, Honorable Chair, it's a clause that deals with definitions, definitions like basic education, which then includes grade R, which was not there. You have a definition of benefit in kind. It's something that was not well defined when you talk to Section 38A, where schools are allowed to remunerate educators extra for extra work that they do, and that the remuneration is not always monetary, but it does build in a lot of other things, such as accommodation, not paying school fees, cell phones, and all that. So that definition was expanding that type of an arrangement. The definitions continue to include a definition of competent assessor. It's a definition
Mr. Ndlebe,
that
apologies for interrupting you, Mr. Ndlebe, apologies. Where the definitions doesn't show a current provision in the SASA, could you just indicate whether it is an expansion, is it a new addition? Is it not changed? Because there's currently nothing in the box where it says provisions in the SASA. So if you can just with each then indicate, is it a new insert? Is it a reduction? Is it a change?
Thanks, Chairperson. If it's empty on the left-hand side, it's an indication that it wasn't there. So it becomes a new addition altogether.
Perfect. Thank you so much. I just want to make sure that, because it's not just the members that are online, there might be people watching on YouTube that doesn't necessarily understand how that works. But thank you so much.
Beautiful. Beautiful. That competent assessor has been given that definition because it's new things that are coming to talk around issues of home scholars, where on a phase by phase, there's a report that is required to show that a learner has been receiving education from those. That's the definition. The next one is the definition of constitution. So because it's appearing on the left-hand side, it means it was there in SASA. And then the definition is then brought to be in line, just the citing of the act itself, and that's the insertion there, and it says by insertion in subsection 1 after the definition of constitution the following definition. So those are the additions that are there, which then follows definition of corporal punishment. The fact that it's empty, it indicates that there was no definition of corporal punishment in SASA. And then it goes on to include all the additions which then indicate what corporal punishment is. Some of these additions, you'll realize, Chairperson, will include things that are not physical in nature, like verbal and all that. And then we're giving the rationale behind on the right-hand side, which indicate all constitutional judgments and all court cases that has led to the introduction of the abolishment of corporal punishment and the addition of what corporal punishment it's all about. So you'll see the constitutional judgment of freedom of religion, South Africa versus the Minister of Justice, the court case of S versus Williams. It's all the things that talk to that. The next definition you'll get is illegal drugs. And then there is an insertion there that means that defines that drug means. And then there are definitions now that are added to the drug. We're still on clause 1, talking to definitions. So it increases all those things that you're saying now are words that are used to define this drug and all the substances that are illegal. The next one, it's the definition of the district present in SASSA. So we defining what an education district is. That there is a policy on districts, and this is now going to align that definition with what you find in this act. Then it goes on to include grade R, which was never an issue in the old SASSA. When you look at it on the left-hand side, there's nothing. So we're bringing it there so that we can define schooling as grade R to 12 for the first time. There is a definition of homeschooling, which was not in SASSA, and we're trying to indicate what homeschooling may mean, and indicate that definition so that when you get into that section, then something gets known. There's a definition of a lone chairperson because it's appearing on the left-hand side. It means it was there. Then the cosmetic changes that are there, that are added into the definition, are then indicated on the right-hand side. This is to simplify. My things are jumping, Chairperson. My apologies. That is to simplify the clauses where we then say a school needs to apply to the MEC if they have to have a loan. And when you get into that, then the definition will have indicated what that means. We have a new definition that we're adding of other financial benefit, which really talks to that section 38A of giving teachers extra remuneration, that it goes beyond monetary gains, but it will include other things like petrol cards. It will include other things like some schools will give teachers grocery, buy cell phone, airtime, and all that in the performance of their duty, which are not illegal in terms of Section 38A, but we're just giving more information and more definition around it. We then have a definition, Chairperson, of a parent. This is important for us to define what a parent is, specifically because when we deal with SGBs and elections, we then define who qualifies to be a parent, because some children don't have parents, they have guardians, and who then becomes a guardian, it has to be defined so that we avoid a situation where people go to school and claim to be guardians of children when the parents are alive and are living with those children, and they just want to be in the SGB. So we clarify that through that definition, Chairperson. still that definition of parent. And then we define special education. And that's the definition that we give in special education, because when you go through the bill, you're going to find SGBs of schools of special needs. Then the other definition, it talks about compulsory attendance, and the changes are in section 3, which brings the following insertion. I hope I'm not moving too fast, Chairperson, for your liking.
You're
Or
not
too slow.
moving too fast, but at special needs education, I'm not sure if it's a mistake, but there's no space between the word to and facilitate. So if it's the same in the bill, then you just need to make a technical amendment to that, or we will make the amendment then, just so that we don't have spelling mistakes in an education bill.
Yes.
Thanks. You may
Definitely.
continue.
Yeah, Chairperson, this was done very much in a hurry. The team, it's all over the show with the hearings all over. Chairperson, my document doesn't show things on the left-hand side. Is it visible on your side?
I can see the document. It's a little bit cut off in the first paragraph. The members have
That's my
also
point.
gotten the document. So if there's nothing in any of the boxes on implications, then you can maybe just make it bigger so that the first 3 boxes are a bit more legible.
Okay. We are now. Oh, my screen is so jumpy.
The first
We are
box
on.
is a little bit cut off still, but not to worry. What we can do is we can also just ask PMG that when the minutes are transcribed on their website, as well as our respective documentation, that they also just upload the respective document as well. Thank you.
Okay. Thank you very much. Section 3 is now dealing with substitution of words, especially to include starting with grade R. Chairperson, may I indulge you and say, when it comes to this section, there's a lot of confusion that I'm going to request you that I reserve this for now, probably end up with it, because the confusion of an enrollment age and the compulsory age, it's so confusing in that sentence that, Chairperson, I think it will take our time, but we want to come back to it when we've dealt with the rest. If
No
the
problem.
Chairperson doesn't mind.
No problem.
Thank you. So that is that section. It's still that section that dealing with compulsory school going age, and which is clause 2. And then move directly to the clause that is talking to monitoring learner attendance.
Mr. Ndlebe, the document just fell off. If you could just share it again, please.
Okay. Is it back, Chairperson?
It is back on, and I think this time we can actually see the full box of the first column.
Lovely. This thing called technology. That is covered ground. I just want to start exactly where we stopped. That's where we are. Number 3, it's empty on the left-hand side because it's a new insertion. It's talking about the management of learner attendance. It's beginning to suggest some roles and responsibilities that principals and school governing bodies need to play as soon as the child is not showing up at school. And this is trying to deal with issues of learner dropouts so that we identify these learners in good time. And it goes on to give steps that SGBs must follow in checking learner absenteeism. How do you follow up with the parent? How do you record this thing? So it's a new insertion altogether, but specifically for SMTs and SGBs. And the fact that these also need to be reported to the department and get support where support is needed. The next one is admission, which is section 4. You on the left-hand side, that is what was in SASA, which talks about the SGB being the sole custodian that deals with admission. But what you get in the bill now is an inclusion of a statement of the admission policies that are determined by the SGB, having the HOD coming in also as a person that needs to interact with those. And this came out specifically from the case between the department in Gauteng and a school in Rivonia in Gauteng, where the ruling, we put the entire ruling in there on the right-hand side, where the Constitutional Court has indicated that the HOD has a final say on the matters of admissions. And the court has ruled that even though the HOD has a final say, the HOD cannot act unilaterally without working with the SGB to effect that decision that we want to implement in a school. That led us to then saying SGBs need to continue dealing with it, but the HOD will have a final say when it comes to matters of admissions and admission policy. But what you get, which is very, very new, is a whole list of statements or actions that the HOD must comply with when he works with a school around the issues of admission, to comply with that court judgment that you can't just go and dictate. You need to follow certain steps, especially these are steps of consultation in particular, that this is how you consult, and this is how you also involve the communities for the best interest of the child. So you're going to get a long list, Chairperson, as I'm going down there, that forces the HOD to work with the school governing body when dealing with an admission policy that is not acceptable to the department if it's not in compliance with the Constitution in particular. Chairperson, what you see in red, these are words that says schools need to submit their policies to the department. It gives timelines when to submit. It also gives timelines by which the department needs to respond. But when we went to National Assembly, Chairperson, we have requested these statements to be removed. But to our surprise, when the document came back to you, we realized that it wasn't removed. We still want those statements to be removed, Chairperson. We still believe the words of the public, especially school governing bodies, that were saying it is undoable for every school to be developing a policy and send it to the department. So why we bought into that is that currently circuit managers and officials do work with schools. They do have religious policies. They do have all sort of policies in their schools, but they were never submitted for approval. But what then happens is that in the line of duty of those officials, should there be a policy that is picked up to be in violation of the Constitution, it can be dealt with at that level without it having been shipped into the department. And the timelines that are given for the department to respond, we may find a lot of policies that get approved by virtue of the fact that the department didn't respond within the 60 days. That is why everything in red, Chairperson, we're still proposing even now that under the guidance of honorable members, we then continue to remove it as discussed in when we are meeting with the National Assembly.
President Lebe, just so that we are quickly clear on the red part. So the red part is what you want the members in the respective provinces and the members of the public in the respective provinces to consider whether or not we wish to propose an amendment in that regard based on your reasoning.
Correct,
Okay.
Chairperson.
Perfect.
Yeah.
Thank you.
In fact, there's a statement that came from the members of the public and we said it makes sense. And then we considered them before, but how they were brought back, we're not sure. So it goes on, Chairperson, to indicate what I've said, that when the HOD interact with the school on a policy that they have developed, there are clear guidelines on what the HOD can do and what he cannot do around it. So the main changes from the previous SASA is the inclusion of the role of the head of department. When you go to number 6, which is a language policy, it is a cut and paste of the previous policy. The one on admission, word by word, is the same, where we now bringing in the role of the HOD in intervening if there is a language policy of a school sorry, that is not in line with the Constitution. And we're giving a lot of court judgments on the right-hand side that has influenced the rewriting or the amendment of that. But the main amendment is that previously, when HODs determine, SGBs determine a language policy, it was a full stop. Nobody will do anything. Whether it's right or wrong, the court were happy to stand on the side of SGBs and say, yes, your SASA says that. But as this court judgment continues, you then realize that SGBs can do these language policies and admission policies, but surely there must be somebody who is able to interact with them in case something wrong is found in those. It follows the same style, Chairperson, where it says, HOD, this is your job. You can't just jump in. You can't just go and dictate. You have to follow this line of march and work with those SGBs until you find a resolution, involve the communities where this school is situated until you then find one another. The red things are coming back, Chairperson. Like I said, it's a copy and paste of the previous one. So the reds are also those things that we're saying we can live with them, where the SGB is expected to go and deliver this language policy to the department, and the department must give an answer. So those are the rates that we say they can be removed as suggested by members of the public. It's still steps that the HOD must follow and never skip them, so that it doesn't become a ruler of this, but it becomes that consultative process until a decision is reached. And the appeal mechanisms are also indicated there should the HOD deadlock with an SGB on those issues of language. 6, it talks about curriculum and an assessment. It was there in SASA, but here the addition is the permission that the minister is requiring to appoint people, an organization or group of people to advise him or her regarding curriculum issues. What we're trying to deal with here is that should there be a need to change some curriculum issues and assessment, when the minister acts and appoint people, there'll always be a question, what piece of legislation covers you to do that, minister? Where do you get the authority? Now, normally when a curriculum is determined, there are a lot of researchers, university people, consultation with unions. In some aspects, SGBs that do get involved and other organizations. So if she have to convene them, she need to be saying, I'm convening them on the basis of this section of the act. And that is the permission that is being sought here, that she do that being covered by an act. Section 8, it talks about the code of conduct of learners. It was there in SASA, and it indicates what schools must do to develop the code of conduct. But what you get as something that is added is the statement that learners must be involved, parents must be involved, teachers must be involved in the drafting of the code of conduct. And when it goes on, the one major difference from what you find in the old SASA and the new one is that I put it in blue, where I say learners may apply to the governing body for exemption of that learner from complying with certain provision of the code of conduct. It will help to give an example. This is a Christian school. All children in this school are expected to be at assembly for a scripture reading. And the learner and the parent says, my child is not a Christian. Can I request permission that you exclude him when you do that? So that exclusion clause wasn't there before. It's something that is coming in afresh, because children belong to different religious faith. It's easy for a child to be exempted from attending a particular activity and say it's a Muslim child during that prayer, allow that child space to pray in a designated prayer room and all that. So we call that an exemption clause, where you can then apply that my child needs to be given space to do 1, 2, 3 within the context of your code of conduct. It's something that is very new, and then it emphasizes on how this code of conduct needs to be developed in collaboration, especially with including members of the community, because the school exists within the community. 8, it's the one that deals with drugs, drug testing. It was there in SASSA, but when you look at the right-hand side, you'll find terms like illegal drugs being removed. I think what led to that is that you have DACA, for example, which is the drug, and the Constitution has said something else about DACA and the use of it, and it means it's not illegal drug anymore. But as soon as the person gets intoxicated, it becomes something else. So we tend to move away from using the word illegal and just talk about drugs. And in the definition, we indicated what a drug is: something stupidifying, something that makes a person high and all that. So whether it's illegal or it's a legal drug, it doesn't matter. If it causes some effect in a child, then it's something that we're dealing with in SASSA. So wherever the word illegal is found, then it is replaced so that it just remains a drug. Because you can find a legal drug from the chemist, but if it's going to make a child to be high, then it's something that we need to deal with. And you'll see right through the document, we're just talking about a drug and not an illegal drug for that matter, for those reasons, that some cough mixtures may end up being a drug to a learner. And if you say it's not illegal, but the learner is high, then it defeats the purpose. Number 9 deals with suspension and expulsion of learners. And there are ways that are changed there, from suspected to accused. And when we deal with these issues, what is new is how the Bella Bill goes to town about serious misconduct. It goes to town to explain the difference between serious and minor misconduct. And these are misconduct that may lead to learner being expelled from school. And it guiding the SGBs on how to deal with cases where learners can be expelled by the SGB, which was not really emphasized in the previous one. The next one is about corporal punishment. The change that is here in corporal punishment is the inclusion of many examples of what corporal punishment is, which include even verbal words, name calling, making children exercise and all that, just to make it more comprehensive and more understandable what is not allowed by teachers in disciplining learners. The next one talks about the prohibition of initiation practice. It was there as section 10 in SASSA. But here, we're trying to simplify it by saying a person may not conduct or participate in any initiation practices against a learner at a school during school activity, in a hostel, in accommodating learners, or at school. It just amplifies what was there and give more effect that this also, as long as it's a school activity, as long as it's a school outing, as long as it's a school hostel, there shall be no such thing as initiation, and the rest remains the same. The next one, it's section 12 that we've added, where the SGB needs to decide if they want to change the nature of a school. Nature of a school into maybe an agricultural school, maybe into a music school, maybe into a school of aviation. It's actually giving SGBs that power to can decide that seeing that this we have or a shortage of this type of schools, we want to convert our school to do that. So it's giving SGBs the authority to then get in touch with the MEC of Education and start the business of applying to convert the school so that it can cater for the subject and the needs that they need, that they want to implement in a school. Then it gives all those steps on what the SGB must do to convert the school. We're seeing a lot of this, Chairperson, in Gauteng, where especially schools that have died a natural death for reason, many reasons that are there, that are being reopened and repurposed to offer certain curricula that was not offered before. So SGBs are allowed to do that. Section 12A talks to the merger of schools. It's there in the merger of schools, but when we realize that there has been challenges around how provinces are merging schools all over the country, we realized that it was not done correctly. There have been gaps in there. So what you're finding in this bill are steps that the department must follow if they were to merge any school. It will give you things like notices in newspapers. It will give you ways of consulting the parents, stakeholders around those communities, the consultation processes that needs to be followed, taking into consideration other factors. It will tell you as you proceed, Chairperson, that small and non-viable schools are not closed at all costs. There are conditions, because there are schools that are small and non-viable that needs to be supported because they may be the only school or they're surrounded by mountains or by rivers and all that. So it's really a clause that speaks to the department more than anybody, that says, department, don't do it the way you want, follow the particular process. So if you, as I'm scrolling down, it's all the instructions that are there. And these instructions are meant also to assist communities out there, that communities can also say, but this step was not followed when our school was merged, and then the appeal processes can begin. So we have gone to town about what must be done before a school can be merged and approved to be merged. So you can see as I'm scrolling down, it's the long instructions to the department. So simple put, to behave when they deal with these things. 21 is still in section 21, which deals with allocated functions of school governing bodies. And then it says the head of department in the new one, the new insertion, the head of department may, in consultation with the school governing body, may procure identified learning, teaching support material for public schools on the basis of efficient, effective, and economic utilization. Chairperson, we have received a lot of guidance, a lot of advices around this, and there has been a lot of misconception around it. And these were based on the fact that provincial departments did somehow procure materials and resources for schools on behalf of the schools without their knowledge and without their permission. And that is why the emphasis here is in consultation with governing bodies, which means if a governing body has not been consulted, there has been a problem. Now, in the consultations that we're having around that, especially from governing body association, they want it to be made clear that if the governing body may be consulted, but if it doesn't agree, the process may not continue, which we want to support going forward, Chairperson, when we go through this and we want to finalize the document, that we will agree with them that permission from a consulted governing body if central procurement has to happen. Why we putting that is an enabling thing that needs to allow even schools among themselves to centrally procure and bring their resources together. Because we're not amending Section 21, where department deposit money to the accounts of Section 21 schools, that is not amended, so it doesn't change. So it means the money will still go to schools, but if we find material somewhere that is cheaper, it means we may go to the SGB and say, have you heard? There's a sale there, you can save money. This is how the central procurement processes have been thought of. So it means rewording if it will have to get acceptable, so that it becomes workable. But the advice we're getting is that, yes, consult, we agree, but let them also confirm that, yes, we're going to participate in this central procurement. Section 15, it talks about withdrawal of functions of SGBs. They have been there, but the emphasis now is the steps that the HOD must take. You don't just find a dysfunctional SGB there and then you just, by virtue of being the head of department, and dissolve it. It says involve them, find out what the problem is, work with them, and when everything else fails, then you can disband that SGB. The emphasis here is the instruction given to education department to follow the law when they are to dissolve an SGB that is not functioning, and give that SGB an opportunity to defend itself until a decision is taken, and then put up mechanism of an appeal if the decision of the SGB doesn't go well. 23 talks about members of school governing bodies. The original SASA allowed for co-option, as you see it in the left-hand side. But it was saying co-opt members within the community. But this one is saying you can co-opt a member or members of the community or persons outside the community with relevant expertise to assist you in discharging your SGB function. So the change here is you are not limited to the community. You can find skillful people anywhere to assist you to perform that role of the SGB. That is the only change that is in there, which the rest will remain the same. Section 17, it's about SGBs of schools with special education. It's replacing the MEC with the minister to determine the constitution, how the SGBs of learners with special needs can be constituted. It is in line with the others that are going to follow, where we're suggesting that the issues of SGBs, especially how they can be structured and all that, need to be gazetted, but it is the minister that will indicate how this need to be constituted. So those are the changes that are in there. And the reason is to try and ensure that SGBs of schools of children with different abilities are represented in particular by organizations that are in that sector. A school for the blind must have organizations represented there that deal with blindness or deafness or physical disability and all that, so that it becomes uniform all over the country that these schools need to be structured in that fashion. And the rest doesn't change. It's basically MEC to minister. Section 18 is new. It's blank on the left-hand side, because schools with specialized focus, schools of talent, were not there before. So the SGBs of these schools are not known how they should look like. Now that is put in so that we can begin to cater for those schools. That the SGB of a school of aviation must have people in the aviation industry. A school that deals with marine must have people in that industry, because the old SATA would only say only parents of a school can participate as SGB members. But parents may not be.
Mr. Ndlebe, you're just breaking up a little bit.
It's load shedding that is changing things.
No problem.
I think in a few seconds, I must be, yes, I've just changed my gadgets now to load shedding.
No problem.
So that clause is meant specifically to cater for these specialized schools where parents may not even know what's going on in those schools, that we change the manner in which their SGBs are elected. So it's something that we have to put in if this policy will have to this bill have to be passed, so that you then see a school that deals with motor mechanics and motor whatever, the motor industry must be there to even assist with the curriculum and all those things. The next one is section 19, which was in section 25 of SASSA. It still deals with those SGBs that are not performing their allocated functions. The emphasis, Chairperson, is what must the department do if they have to deal with an SGB that is not performing its function? And it then goes to town on a step-by-step, inform those governing bodies with the intention, give them a reasonable time for them to respond, engage with them, and it steps that. So it's an instruction to the department that don't just write a letter and say you are disbanded with immediate effect. It has to follow certain things. Section 20 is captured in the previous section 26 of SASSA, which just
Mr. Ndlebe, are you still with us? Mr. Ndlebe, I'm not sure. I'm struggling to hear you. I'm not sure if you're on mute. Mr. Ndlebe may have just logged off in order to log back on. So let's just give that a minute or so quickly. Lisa, I just want to check if everything's okay, if Mr. Ndlebe is able to log back on.
Okay, let me just check with him. We have other members on the meeting. Let me just check with one of them as well if they can continue.
Thank you so much.
Morning, Chair.
Good morning.
Yes, we just spoke to Mr. Ndlebe. He's trying to get back to his presentation. Can you just give him a minute or so?
No problem.
Thank you so much.
Chairperson,
Hi.
it looks like we're back.
Perfect. We were around about clauses 19 and 20, but you can maybe start at 19 again.
Okay. Is it visible?
It is, yes.
Okay. So you say I must go up.
Yes, we've concluded clause 18, which dealt with the special schools co-opting experts.
Yeah.
Then you were moving on to, I think it was either 19 or 20.
Okay. I'll find it now. No, we have dealt with the recusal of SGB members.
Oh, apologies, is that number 19?
Okay, is it 19? Okay.
Which is have a
And
look.
then it's giving steps and what when to recuse.
Yes,
And
you're
then
right. Thank you.
we then spoke to that clause. We are here.
Perfect.
The
Thank
new
you
one,
so much.
the new one that talks to no member of a school governing body may be remunerated for the duties, but because it's new, what it emphasizes is that there has been a clause on reimbursement, that an SGB member who performs a function and uses his own money needs to be reimbursed. This will include an SGB member who takes a taxi to go and attend a meeting and a taxi back home. That money needs to be reimbursed. A member of the SGB that will be asked to go and perform a function, uses his car, he has the right to claim and get reimbursed. What is becoming clear here is that you don't get paid for attending meetings, where at the end of the meeting, people then get a check somewhere. And it happens a lot, Chairperson, where people then get paid for having come to the meeting, and they start making a lot of meetings so that they can get money. So the emphasis is we're not paying. And you will get, Chairperson, when you go to public hearings, that the people might want to fight and say SGBs must be paid. And from our side, we're saying councillors are getting killed oftenly because of these positions and because of the money. We don't want to bring that into our education system. We'd rather have parents that are committed to work rather than people who will be attracted by money to come and do this SGB work. It's done perfectly by those who are volunteering because they love the work that they do, and we'd rather keep it that way. I don't want to get into the financial issues. 25,000 members of SGBs, no country can afford to pay them. I thought, let me just give you this background why we're saying no payment. Elections of members of school governing bodies. I've indicated MECs at the moment, they go through their legislatures and they sign off, and then they have regulations. And we're saying it's taking a toll on us. We just want to have one regulation as we are listening to school governing body associations, and would like the word MEC replaced by a ministerial governing body regulations in that way. And remember, Chairperson, if regulations come from the national office, it means it involves everybody, because that's what the DBE is. It's the provinces, it's associations, it's stakeholders, it's everybody. And that's what we're proposing. Office bearers of SGBs in section 23. The major change here is the insistence that no member of staff can be a chairperson of a finance committee. It was clear the SGB of a chairperson must be a parent. And we're saying the same with chairpersons of finance committee. It was not always the case. We're trying to avoid a situation where the chairperson of the finance committee is a teacher, works with the admin clerk of the school, work with the principal of the school, and then decisions are taken and money is gone. and the relevant stakeholders that are very important in SVBs are parents, and they may not know what has happened. So the new change is that one of, please, let's put the parent as a chairperson of a finance committee. 24, which replaces 32, is just changing words. Instead of minors, put them learners. Because there are institutions where learners are not minors, especially in special schools, where children above the age of 18 in a special school, and they're not minors, they are learners. So as long as you're a learner, we say you can't contract, you can't sign, you can't participate when there are selection processes for recommendation for teachers. Those are the changes, Chairperson. The closure of public schools, 33, more or less is the same as that one of clause 12. What is key here? The problem of schools that are closed without having followed due procedure. We're putting it in law that these steps that are long must never be skipped. They must be followed to the latter. So that is an instructions to provincial departments that if you have to do it correctly, or else don't do it at all. So it's a long instructions to the MEC, which makes every community member to know and be able to hold the department accountable if they are not doing it correctly. Section 26 was in section 36 of the previous one. We're substituting words there, dealing with lease, and say they have to be done, especially with the permission of the department. It's more or less the same, but words are being shifted. Chairperson, here when you talk about lease and all that, I need to indicate something that we did in the previous document, where there was a clause that says the schools must allow the department for the use of their facilities free of charge. We have removed that because the schools fundraise by making use of their facilities. So if it's being brought up, it's no longer in here. Just to allow schools to run their facilities without really the influence of the department. It's what the public was saying. 27. Just the change of the word direction to directives. Lawyers can explain better what is the difference between direction and directives. Apparently, the word directive is the one that is used now. You remember during the COVID era, we had a lot of directives that were coming from the NetJoin, and the department came up with a lot of instructions on how to open the schools and all that. So these were not called directions, but they were called directives. So that's the only change that is in them. The old SASA still prevails. 28 has some changes of 38 about annual budgets. The emphasis here on annual budget is transparency, making information available to parents in good time. And the main change that is coming in here is the word deviation. If a budget is passed in September, because we normally do it in September, and the school wants to deviate, it's giving them permission to deviate within 10% of the deviation. But if the deviation is more than 10%, they must then have another general meeting and inform the parents about the deviation and how it's going to affect them. So it goes on to indicate the steps that the school must do if they want to deviate from the approved budget in September by parents. because things do change. One other addition, Chairperson, is I've just skipped that word now, the word quorum. The old SASSA says the budget will be passed by the majority of the parents in the meeting. You will find 10 parents coming to that meeting, and if 6 of them say yes, then the budget gets passed because the majority of the parents in the meeting have spoken. The new changes that are there are changes that are saying for a budget to be passed, the school needs a 10% quorum. Then the budget can be passed. So that's something new. That if they call up a budget meeting and there's no 10% of the parents, then the budget cannot be passed. Chairperson, I'm tempted to talk more about a quorum. A quorum is not determined by the number of children in a school. A school may have 1,000 learners. It doesn't mean 10% is 100 parents, because out of those 1,000 learners, there are 3 children that come from the same family, so you can't count them as 3, it's 1. There are children that have single parents, so the percent is counted on the basis of the parents on the school register. We're going to SGB elections now, we do a voters roll. A voters roll will indicate that this child has 1 parent, this is the name. This child has 2 parents, these are the name. These 3 parents belong to the same parents, these are the name. So you count the number of parents of the school in order to determine a quorum. So 10% of the names of parents on the school register will then determine the 10% and not the number of children. I thought, let me just indulge you on that one, Chairperson, so that schools don't get confused and start taking calculators and say, what is 10% of 1,000? It doesn't work that way. So the quorum is even far lesser than what is expected when you use the number of children. It has been done so that decisions at least get that authority that, yeah, there were people that have taken this decision. Section 38A still talks about payment of staff. It's not changing anything. Schools still have the authority to incentivize their teachers, but according to the definition, we went to town about benefit in kind, which must be indicated, and that schools need to be transparent and apply that they will be paying teachers for these type of activities, how they'll pay them, when they will pay them, and they are doing it, but it's just that there were other issues that were outstanding. And the fact that schools were not very transparent to the parents when they passed the budget. So they need to show these things, that all teachers in this school are not allowed to pay school fees as an incentive, so that we recruit the best and incentivize them. Please put those things, let them be known, and they should not be done secretively. And there's nothing illegal around those practices. Just make sure they are known. Enforcement of payment of school fees. Chairperson, our laws say if it's a fee-paying school, parents have a responsibility to pay that school fees if they are liable. If they have an income and they can afford it, it's up to the school to track, get proof, and then demand that school fees. There's nothing that stops a school from dealing with a parent who's not paying school fees when he's supposed to. But the changes that are coming in here is that we do get single parents who apply to a school, and then by virtue of single parents, they have to apply for exemption if they can afford it. But when schools start to interact with the financial statement of the parent who's applying for school exemption, more often they are asked to go and find the father of the child so that they can afford the school fees. So that clause has been put in to protect single parents, especially those who are unable to trace the father of the child. And where the father of the child is unable to assist with schooling, the school has the right to go after the father where possible. But when these exemptions are applied for, the parent who is a single parent can use issues of affidavit and give all the financial records to the school so that the school can calculate how much exemption the parent qualifies for without really bringing the partner that has disappeared and is not in the life of the child. Those are the changes when it comes to the school fees issue. It does happen even in admission when a parent applies for a child, they say, you are a single parent, where's the father? Bring him so that you can both sign the forms. And some of them don't even know where those fathers are. 42 in the old SASSA deals with financial records and statement of public schools. And then the changes that are there are those financial records that the school must keep. And it says in the old SASSA, annual statements which are audited needs to be provided to the school at the end of a financial year. The financial year in a school starts from January to December. Then schools are supposed to start working with their financial statements up to 3 months thereafter. And the audited financial statement can be submitted in June of that year. That is 1 year, 6 months of working with statements. And it says, yes, let it continue in the same way as decided there. But there is a new addition, an addition that says the head of department needs to be given the authority to investigate all financial mismanagement of a school suspected of such. And the head of department can also request the Office of the Auditor General to undertake such type of responsibilities and investigate. What is becoming very controversial, which is being challenged, it's the fact that the department is requesting schools to even provide their financial statements, the income and expenditures on a quarterly basis instead of waiting for that one year, 6 months. And those are changes that are there to provide those statements to the department on a quarterly basis, just not audited, but just income and expenditure statements. 46 in the old SASSA, it is in 33 in the Bella Bill. It's just about the registration of independent schools, criminalizing those who open schools without permission, without having applied to the department, and putting penalties for those. This is what we call fly-by-nights, unregistered schools that are found mostly in the cities, that we putting penalties around those people who want to open those schools without. And 34 is just the subsidy to independent schools, which are done by the department. There's something that says it is the legislature, it is the MEC that does that to decide how much, depending on what the provincial legislature has given to the department, then they work it out. So it's still emphasizing the authority of the MEC in the determination of that, and it should not be that of the minister because the funds are in the province for that. 51 was about homeschooling. And what happens with the Bella Bill now it's going to town on homeschooling. And this is something that is around the Constitution, Section 29(3), which talks about registration, which talk about the curriculum which should not be inferior to the one that is offered by the government. And then it starts to indicate the need for registration, how this needs to happen, how the department needs to work with the parents that are applying, how the parents need to commit to having the child assessed, but not by the department, by a competent assessor. It's something that we have defined before. And how the interaction between the department and the parent needs to happen in ensuring that this process is done smoothly. In the previous Bella bill, there was a statement that the department will do home visits to verify the place where these children are going to be taught. After many opposition, that statement is no longer in here. So there will not be home visits, but there will be those applications, and the department needs to oblige, because this section is covered in Section 29 that it must happen. We're not taking the powers of any parent who want to homeschool. They can do that. They can follow a curriculum of their choice. The only thing the Constitution says that curriculum must never be inferior, but it still remains the curriculum choice of a parent to homeschool the children. It also makes it easy after a phase if there is a report from the assessor, in case the children have to come back to government schools or even independent schools. It assists in the placement of those learners. So it goes to town about how to regulate that relationship between the school, I mean the parent and the department. It's still those things that they say the department must do for the sake of the child. 59, which is 36, talks about the duty of the department to provide information when requested, but what comes in addition that is serious, which was never there before, is to criminalize falsification of documents when parents apply for either admissions or for school exemption. Parents do bring documents that are not genuine. They do sometimes even get a stamp from the police station to certify this is the true version. And we're saying, should that be discovered, that the documents are not correct and are false, then we're criminalizing that, and we want parents to be taken to task. It happens especially with admission, where parents will come and say, I live here, here's my home address, and here's my proof of address, only to find that the parent doesn't live there. You'll only realize that when the child starts coming late to school. And when you ask, why is this child late? Then you are told, he lives far. He has to take 3 taxis to come to our school. But in the file, it says he lives next door to the school. These are things that we want to prevent. And those who don't want to pay school fees and hide behind false documents as indication of their income. So when that gets discovered, that's what the clause is all about. Clause number 37, something new. There will always be disputes between SGBs and the department. SGBs and the communities, especially communities and the department. That is a new clause that is giving the rule of engagement. What happens when parties are not agreeing? So it gives that Bible, that instruction, that parties, this is what you do. You write to one another, you meet with each other, If you don't agree, you find somebody who will make you meet and agree. If that fails, you follow this. Those are the steps. And you'll realize that these steps may not differ with the steps on language policy and admission policy, because if there's a difference of opinion, it then have to be done in that fashion, including when it goes to an appeal and having other people to come and mediate where possible. Section 60, which is now 38, talks to the liability of the state, where we're indicating what we may not be liable for if there are this destruction of property in a school, which is just an extension of what was there, no major changes there. 39, it's about learner pregnancy, where it is not regulated. All we know is that the Constitution demands that children are at school. But when they are at school, what do you do with a pregnant girl? How do you treat that? Now, the request here is there need to be steps, regulations that need to be promulgated to indicate how to support pregnant girls at school, how to work with them, how to involve the Department of Health, when to request a child not to come to school because it's about you, what happens when these children miss. So these things that I'm referring to are not there in the department, and teachers remain with pregnant girls, and they're not competent enough to know what to do and how to deal with it. So that section is just to say, can we have regulations? And our understanding of how regulations come to be is that the department will lead, but it works with professionals, it works with associations, it works with teacher unions, it works with specialists that will advise on what happens. Then there'll be consultation. If it passes, then that will be regulations that are regulating learner pregnancy in a school. So that clause is basically a request so that when the minister start working with that, we'll say, in terms of this section, I'm now putting up a team to put up regulations that will regulate learner pregnancy, because I've been given authority through this section. That's all about that section, Chairperson. 40 is new, it's just changing the preamble of the South African Schools Act, and putting some words and some great arts in there which were not there. And these are some of the things that you're going to get in there. And it will have other words such as basic education. When SASA was promulgated, it was the Department of Education, and now it has changed to basic education. So that necessitates the changing of the wording of the preamble. And the old SASA will have adult basic education, because these are terms that were used then when the department was Department of Education, where higher and basic were together. Now, adult basic education belong to higher education now. So in these words are found in the Employment of Educators Act, and then this is how they get changed. Other words that are there, especially adult basic education centers, it's a continuation that we no longer deal with those things as basic education. Further education and training can be in our SASA because it belongs to higher education. Those are those changes. Educator establishment, those words again, further education and training. It's an educator at school or further education and training institution. So we're removing what belongs to higher education and remain with what is ours. So those are cosmetic changes. And then appointment and filling of post, those words that don't belong to us are the words that are being removed. You'll see even words such as cancel. The cancel was there because higher education uses cancel and we use SGB. So we're removing cancel, we're remaining with our words, which are SGB. Same thing, we just clean up the Employment of Educators Act so that it really speaks to us. Secondment of educators, you'll find that it has to be done with the council, with the SGB, and this is what we're cleaning. Institution or centers, no, for us, these are schools. So it's more editorial. Serious misconduct, Chairperson, this one in the Employment of Educators Act has added a lot of issues that are considered to be misconduct by teachers. So that's a major inclusion in the Employment of Educators Act. And it goes with 18. That's where the serious misconduct of teachers are in SASSA. And then we go on here to even clean up the wording and also add what is considered to be serious misconduct by teachers under Section 18 of the Employment of Educators Act. So from here on, going on, you realize it is those cosmetic changes and how you deal with it. No changes about the warning and all that. Here is a major one. Section 59, it focuses on teachers not to do business with the state. It doesn't stop teachers from having businesses outside. There's a law already in education that says they must apply if they want to do additional businesses that gives extra remuneration, as long as it doesn't affect the normal working hours and the teaching hours. But this one, it's really saying you can't be selling stationery and run a tender with government. You can't be providing school nutrition under the contract of government. So it's actually saying you can't run your business through the state. The last one, it's Section 35. It's just those changes and cosmetic, just to make sure that the language is aligned to the new SASSA. Section 38 of Employment is repealed. It's no longer relevant, so it has been deleted. And 52 cosmetic changes of those words of further education, public adult education, and just make sure they are no longer there. And 54 is the name of this bill as presented to you, Chairperson. That closes this aspect, Chairperson. That's how we put the old and the new together and try to give a rationale where possible, Chairperson. May I hand over back to you?
Thank you so much, and thank you for that presentation. Colleagues, what I'm going to do now is, because clauses 40 to 54 seems very technical word changes, I'm going to break the question and answer session up into clauses 1 to 20. So if you have a pen, clauses 1 to 20, then we will deal with clauses 21 to 40, and then we will deal with 41 to 54. So colleagues, if you have any questions, we're going to start with hands now on clauses 1 to 20. So I'm hoping that you made notes. If there are no hands, I have some questions. Going once, going twice. Okay, I'll start. Mr. Ndlebe, I just want to check with clause 14. that relates to the allocation or the allocated functions of governing bodies. It dealt with central procurement. You mentioned the department as previously procured for schools without notice and it became a problem. I would like to understand, obviously it says then now, you're going to get permission from the SGB, but what is different to this clause and the clause in the public procurement bill currently dealing with transversal procurement? Because my understanding of transversal procurement in government and state organs and organs dealing with public functions is that you need to give permission anyway in order to be part of a transversal agreement. But central procurement is a little bit different to transversal procurement because central procurement, you don't have as much say in it in comparison. Whereas transversal procurement, you're essentially saying, you're already doing X, we would like to be part of your contract. So how is this clause different to transversal procurement? And then in clause 17, where you replaced the words of the MEC with minister, relating to the election of members of an SGB public school for learners with special education needs. I just want to understand, why is it being changed from the provincial minister to the national minister? I don't understand the change. If we can just try, if you could just please explain that to me. Has there been problems in provinces? Because I don't understand the rationale behind that. And then my third question for now is in clause 19. The clause 19 dealing with the HOD being able to dissolve an SGB if it ceases to perform functions based on reasonable grounds. It mentions, if I remember correctly, it said 14 days for appealing. And while for state organs in general, 14 days seem reasonable, if I think of a general organ dealing with a public function, I'm just trying to understand whether it would be practical for an SGB if 14 days would be enough time to be able to deal with the respective appeal. But those are my questions for now. I just want to quickly check if there are any other questions for clauses 1 to 20. If none, Mr. Nlebe, over to you.
Thank you very much, Honorable Chairperson. An SGB is a jurisdictic person. And there is this thing that the SGB, there's a school under the SGB doesn't really falls or manage under the PFMA. So in short, the PFMA doesn't apply to schools. So when you talk procurement of goods and it's a Section 21 school, it means they have the authority to go anywhere they want and make that purchase. So a transversal tender, for example, it's something that happens in the department, and you getting into the space of PFMA that regulates how these things are done, which the school is not bound to follow that. Now, why it's coming in here is that sometimes the department has that buying power. I could give you an example that we do have textbooks that are selling at 300 rands a copy. But when the department gets involved, they may be able to buy that textbook at about 100 rand or 150. So it is these issues where if we manage to have negotiated that price, we need to go back to the SGB and say, we've got a bargain here. If you want this book, they can be procured centrally, and then you get involved. But remember, the money is in there. When I was explaining that provinces used to do that, it's not your province, I must say. And the courts have ruled against it and say it was illegal. What would happen is that when a school is expecting to receive its 100 rand because they are Section 21 school, that 100 rand doesn't come. What happens is a delivery truck that is bringing material and say, we have used your 100 rand to buy books on your behalf. So that is illegal. And the courts have emphasized it is illegal. And now we're putting it in a law that says, unless the governing body, if we agree to put it that way, has agreed, don't do that anymore. It is that type of explanation that these transversal tenders that happens are for government, so that you don't go through the process of advertising a tender when already there is a service provider that is doing this job well. And nothing stops schools to jump into any type of agreement. All we're looking for is the economies of scales here. But the authority still lies with the SGB. And Section 21 doesn't take that authority. They still have the money in their hands. They can still decide what they want to do with their money. The rider might be an SGB that will insist to go and buy material in a place that is so expensive, same material, when they have been directed that it's cheaper in there. That can bring in some discussions around the table. Why are you insisting on going there when it's the same tin of baked beans made by the same company, but yours is too expensive? Elections, why it's replacement of the MEC with the minister. It is the elections in general. It is the members of the governing bodies that need to be there. You wanted to know what is causing that, what problems are we experiencing? The problems that we're experiencing is that you will go, for example, to KZN, and you get a complaint that our learners with special needs governing body, the province is not allowing us to bring specialists, is not allowing us to bring in sponsors to be part of the SGB. Then you get to another province and say, in this province, they are allowing us. You go to another province where children are homeless, but they are in a school, and you need to have that home where these children are to be a member of the SGB, and they're told you are not a biological parent, you can't come in. So these differences from province to provinces are the ones that are saying, let's have them being regulated at national level to bring about that uniformity. That is the reason, Chairperson. And the dissolving of the SGB within 14 days. There are a lot of dates in education laws, whether it's an act, it's a policy, and all that. And what we have been trying to do, especially with working with SGBs associations and provinces, was to try to have a uniform timeline for most of the things. Notices for SGB elections, 14 days. When a learner has been charged with misconduct and then there's a request for the learner to be expelled, 14 days. If the SGB elections did not sit, 14 days. If you have to send notice for an annual general meeting to pass a law, to pass the budget, 14 days. So we were trying not to play too much with the dates that people will get confused. How many days for that? So 14 is standard in most of the documents in the department. And this is the work that we have done with associations and legal services and provinces in particular to say, somewhere it's 21, somewhere it's 14. Can we just agree? But Chairperson, you remember that this bill is now in your hands. If honorable members feel that now you're crazy, we're changing it. Fine, Chairperson. Those are 3 questions, Chairperson.
Thank you. I have another 3 on the first 20 set of clauses. Firstly, you indicated earlier you're going to come back to clause 2, dealing with the grade R enrollment age, school-going age, and so on. So if we can just maybe get some clarity on that clause 2, please. And then on clause 7 regarding the code of conduct, the word just cause, I just want to understand what exactly does that mean? I didn't see specifically how you determine just cause. And then in clause 8, you obviously took the word illegal out of the word drug. Now, that obviously then means that it could include prescribed legal medicine, but how will there be conditions attached as to how educators or schools are able to distinguish between someone who is on prescribed and or legal medicine, but not, as you argued, high or under the influence in comparison to it being okay? It seems like that is a little bit wide. I'm not too clear on the explanation regarding schools section 21. I do know that section 239 of the Constitution also deals with institutions or functionaries exercising a power or performing a function in terms of the Constitution or a provincial constitution, or exercising a public power, performing a public function in terms of any legislation. But I think that is a little bit of homework for myself just to read up on. But just those first three, please, and then I will move on to the next round. Thank you.
Chairperson, I'm sure you heard in the introduction, I have 3 members of the legal service with me today here, and that they will add on some of these issues, especially where there are legal implications. Why I said clause 2 is that I can confess, even when I read it myself, it doesn't make sense. But this is what needs to happen. We need to differentiate between an entry and admission age and a compulsory school going age. There's a difference between the two. The old SASSA has put it very clearly. The admission age of a child going to grade 1 is a child that is 5 turning 6 in June. That is the admission age, which is 5 turning 6 by June of that year. But the school compulsory age was 7, meaning that no 7-year-old must be without a school, homeschooling, or private schooling. At 7, it's compulsory that the child must be receiving education, but the starting age can be anything else. Then we introduce in grade R, and the entry age of grade R is a child that is 4, turning 5 turning 5 that year in grade R. But when you read 2, it then confuses the entry age and the compulsory school going age. And it's so confusing that it does not make sense. And it's something that requires us to really make it clear that if 7 it's a school compulsory age, let it be clear. Because it doesn't always mean that a 5-year-old needs to be at school doing grade R. Parents still have that right to say he's not matured enough, he's not ready. Then we can only start making noise when the child is already 7 and nothing has happened, has not been at school. And this is where the public will be saying, now you want me to take my child who's 5 years to school when he's not ready, and if I don't take him to school, you're going to send me to jail. It's because we did not put words clearly that the child starts at 5, but it's not a compulsory school going age, and therefore that age can be delayed and the child can even start later we're not very specific around that, Chairperson. It's something that we need to do probably as soon as possible, so that when we start discussing the clause by clause and we're indicating what comes in, what goes out, we should be ready by then and make something that makes sense. And that's why I said I didn't want to go through in there because it confuses the way we understand it and the way we want it to be. You said you'll do the homework on public power and those who do work on behalf of the state. So let's leave it. I'm sure Chairperson will give us a call or a WhatsApp and say, hey, this is what I found, so that we can make it more reader friendly and more understandable. And the illegal drugs, my explanation was that not all drugs are illegal, but some drugs may have negative effect, which will not be desirable at school level. And when children come to school having medication that we don't know what it is all about, I think it indicates they need to have that prescription. They need to have something from a doctor or a pharmacy that says the medication has been handed out by us and this is what it does. Because a simple medication like a cough mixture, when children drink it in large quantities, it's not a legal drug, but then it has this negative effect. Then in the bill, we should be dealing with the drunkenness that was caused by a cough mixture, and not deal with the cough mixture per se, but just to say you are high. But let me allow my colleagues who may explain this part much better than I can do. Thanks, John. Colleagues.
Thank you. Mr. Ndle, which colleague is going to assist with legalese?
I have lawyers. Lawyers, please do come in.
Just so we can get some clarity on some of the sections that was indicated, that it's not necessarily very clear to some of us how it is written or what it means or how it will be implemented.
Mr. Lucas, would you like to take that?
Sorry, I was just interrupted for a little bit. Let me just go to the clause on just the question on just cause. So that that phrase just cause is not it's not new in the SASSA. It has been used previously in the SASSA, but in this context, in respect of the clause 7 on exemption, what it means is that there must be some justification for a parent or a learner to apply for exemption. Justification, in the sense of if the learner applies for exemption on the code of conduct, then there must be something like, the learner is for religious reasons. The learner apply for conduct, perhaps as the example that James used of a Christian school where a Muslim learner do not want to attend the scripture reading. So that would be a just cause. So this phrase would then protect both the parent as well as the governing body, it is so there must be a good reason. One can use other phrases as well. Just cause has been used previously in the SASSA, and for continuity and for uniformity, the phrase has been used here in this particular clause. But if the committee feels that there is a better clause, a better phrase to use, then so be it. They can then use a phrase that I think should that is more clearer. On the issue of illegal drug, I think as James has previously explained, there are certain drugs that now has become legal, for example, dagga, so you don't want a drug that's got a stupefying effect. If there is a drug that is prescribed to a learner, then I think it is the responsibility of the parent and bring that to the attention of the school to indicate that my child is on these type of prescribed drugs. It's used for X, Y, and Z, a medical condition. So therefore, that drug may make the learner a little bit sleepy. So just be aware of that. There is also in the safety regulations also a responsibility on the parent that where a learner is on a prescribed drug that may have an effect on the learner, that be brought to the attention of the school. So prescribed drugs in terms of would not be a problem as long as that is brought to the attention of the school for both the child's safety as well as for the school to be informed, in case there is the learner does have the learner's condition may be deteriorate, that the school is aware of that. And the school can then act and inform the parent that there is a problem. Chair, I may have missed your question on, did you ask the difference between Section 20 and 21 schools?
So I just wanted a little bit more clarity on the central and transversal procurement as to how that affects SGBs. Mr. Ndlebe did indicate that obviously the PMFA doesn't apply to schools that are Section 21. I think I was referring to more in terms of administrative law, that it's not just the PFMA. There are other laws that deal with the exercise of a power or performing a function in terms of the Constitution, or exercising a public power, performing a public function in terms of legislation, in terms of Section 239 of the Constitution. But perhaps that might be easier in terms of a written answer. But if you have information, I'd really appreciate that. And then Mr. Ndlebe also attempted to explain to us the enrollment age and school-going age in clause 2, but he also indicated that, when you read the clause, it's very, confusing. So maybe if you could assist with trying to unpack some of the legalese in that clause for us.
Yeah, I'd say the intention of that clause is really very simple, and that is to make grade R compulsory. Grade R is currently not formally in the schooling system. So currently, the situation is that there is a compulsory school age. So parents are obliged to enroll a child when the child reaches the age of 7 years. A child can be enrolled earlier than that. A child can be enrolled when the child turns 6. By June of that year of admission, the child can be enrolled for grade 1. But 7 years is the compulsory age. So a child that's 8 years old must already have been in the school. It will be illegal not to enroll the child when the child is still 8 years old and at home. So 7 years is the compulsory age. Then there's another provision in the SASSA that deals with admission ages. And that is Section 5 of the SASSA. Specifically Section 5 sub 4 that deals with admission ages. So the difference between 3 and 5.4 is that 3 deals with the compulsory school age. 5.4 deals with admission ages. So your compulsory school age is It's just to say that a child that is 7 must be in school. It's compulsory. However, you can enroll your child earlier than that. And that is what 5.4 of the SASSA deals with. 5.4a says that the admission age of a learner to a public school to grade R is age 4, turning 5 by 30th June in the year of admission. And grade 1 is age 5, turning 6 by 30th June in the year of admission. So a parent has the right to enroll a child then in terms of that particular provision. Now, because grade R is compulsory, the compulsory age must now be changed, because it can't now be 7, because you can't have a 7-year-old in grade R. So the compulsory age now also needs to drop. It can't be 7 years old to cater for when a child now reach the age of when a child is in grade R. But Chair, I must admit that, you know, these two provisions, and it can cause confusion. And this is how it was drafted in the SASSA, and this is how it currently is. So we were as drafters, we were faced with the task of making grade R compulsory, and one of the things that we were looking at was the compulsory attendance age. In other words, to make grade R compulsory, you will have to then amend the compulsory school age. But Chair, again, this bill is in your hands. If you can find a way to do it that is clearer, that is up to you, how you craft it and how you can then come up with a clearer idea on this. But the purpose is we want to bring grade R into the mainstream. It's currently not in the mainstream. It must become compulsory, so every child must be in grade R. That is the main thing here. How we can craft it, Chair, that you have as legislatures, you have the responsibility. Then also, this is your bill also now, so you can see how that can be, how you can do that better. Thank you, Chair.
No problem. And I know that we did indicate that we're going to ask yourselves and National Treasury just to come and present the costing of the bill, because my next question would have been, how are we going to pay for grade R even if we agree that it should become compulsory? But I will wait for our session on costing and finances for that. I'm opening up, colleagues, now clauses 21 to 40 for questions. Again, if there are no hands, I have some questions that I would like to pose. Okay, in clause 22, it again replaces the words MEC with minister when it comes to determining elections of SGBs. And I just wanted to find out why each province can't determine how the respective elections occur. I'm not too sure regarding the reasoning for that. Then clause 25, it deals with the closure of public schools. I just want to understand how exactly the steps are going to work. Mr. Ndlebe, you went quite quickly through what those conditions and factors are for when you close a public school. And then let me stop at clause 26, dealing with SGBs having to seek approval on loans from the MEC. I'm just trying to understand, because some loans could be small loans or it could be small matters. Is every school, every single time they're going to go into a loan, going to have to ask their provincial minister to approve it? And when you look at the way that the clause is written, it then also makes me think, okay, but if it's good enough for provincial minister to be dealing with something like this, why are we changing some of the other clauses from provincial ministers to the national minister? It seems like it almost like it's unnecessarily taking powers away from the provincial minister. I'll stop at those 3 clauses. Thank you. Mr. Ndlebe, are you able to hear me? I just want to check if anyone else is able to hear me. I did go over into load shedding and I did switch devices, so I just want to make sure that I am audible.
You're audible, Chair.
No, Chair, you are audible.
Okay, no problem. Mr.
Chairperson,
Ndlebe.
yeah, I was cut off, and what I heard was the election, why the minister and all that. It creates confusion. Like now, you will be told that the quorum of the SGB election should be 15% of the parents. And then you read the regulations in the province like Western Cape that says the quorum is 10. Now people know the elections to be determined at ministerial level when they must take place and all that. There were a period of time when provinces will decide on when the elections are going to be conducted. So it really confused the sector. Until such time that these SGB associations that we work with in the sector said, can we stop this thing? And stop it, and the challenge is still continuing. I said in my presentation, where I'm sitting now, I have regulations that have been promulgated, and the elections are starting on the 1st, and there are provinces that haven't done that. And it's not fair for the public to know what they need to go and elect on. So it is for this reason that a suggestion was taken that let the minister simply regulate on this SGB election so that there is uniformity in terms of the number of parents that can be elected, how the ELSIN schools need to be, how specialized schools the members must be, what is the quorum, and what are the notice period before, what mode of election do you use? We're using 3 now. A province just decide, I'm being specific now, when we all agreed as a country that we're going to allow electronic elections in 2021, then Gauteng says we're not going to do it. Even though systems have been put in place and the organizations that were ready to run that, it is those things that says, rather, let's not have regulations that come from individual provinces, but let them come from the ministry. Chairperson. That's the one I had, but I hope the colleagues will be able to respond to the others that I didn't catch.
I'm not sure if Mr. Lucas is dealing with my other 2 questions regarding clauses 25 or 26, but just to repeat, the first was regarding what are the conditions or how are the steps going to work regarding the closure of public schools, because we went through that clause really quickly. And then in clause 26, dealing with seeking approval on loans, I'm just trying to understand the practicality of an MEC approving every single loan from every single SGB in a province.
Thanks, Chairperson. The issue of the loan, I think that's one of the questions that was asked last week by the legal service of the Western Cape, that we're playing around with MEC, we're playing around with heads of department, and I think it falls under that category because it might be an administrative function, not an executive function, which we said, yeah, it's things that we can agree on how it can look better than just giving everything to the MEC when he's not an administrator. And the other one that you're raising, I'm missing something here. Chairperson, please remind me.
It's clause 25, the
Yeah,
closure of
yes,
public schools,
closure,
and
yeah.
what will be considered. What are those steps? What is the 1, 2, 3 that needs to be adhered to before you consider the closure?
Yeah. Schools that are regarded as small and non-viable, which needs to be merged or closed, are schools that are having less than 135 learners in a primary school and less than 200 in a high school. The reason being that the department provides teachers in terms of the number of learners at the ratio of 1:40 or 1:35. So a school that has less children, say probably 100 for that matter, it means it can get about 2 teachers, or probably 2.5. And it's not possible for these teachers to can teach all the subjects that are supposed to be there. They will also not be able to teach even the number of hours required per subject. And it becomes impossible for those children to receive the quality education that they deserve. So what then happens under those circumstances is that the department must begin to look at the possibility of merging 1 or 2 schools so that there could be this quality education that takes place. So for that to happen, there is a need for the department to work with those schools that they want to merge and indicate to them the challenge and what they think needs to happen. And then consultations need to happen with the SGBs of those schools that we wish we could do the following. And this is how do you think it must happen? So it's not a matter of the department saying this school must move there. It's a matter of together, which school has better facilities? Together, do we have scholar transport? Together, how are the teachers going to be moving? So it will bring in stakeholders, SGBs, unions, because teachers belong to these unions. And it is at the end of these discussions that the minister, the MEC, will then advertise on local newspapers of the intentions. And people will then be given an opportunity to respond, whether they support or they don't. Then there'll be these meetings that happen, those engagement. Should a decision be reached that we're merging, then the teams together need to put up systems on when the merger is going to happen, how is it going to happen, who's going to be the principal of the school, how are the teachers going to be moved. Now, should the communities resist and they give valid reasons why this merger must not take place, then it can't take place. But if the community resists and all these steps have been taken as for the benefit of the children, it means the negotiations go on forever and ever. But what is key for us is that it is never a measure of schools at all cost. It is a measure of schools where it is doable. If you don't have scholar transport, you can move. If you don't have a physical environment where these children can be grouped, they can move. If, for example, these children have to cross a river and mountains and all those things, it can move. If the curriculum needs of the children, and so that clause, it's giving what is it that the department must consider before it thinks of merging schools? And if it thinks of merging schools, what steps must it take to ensure that everybody's on board and nobody's left behind? So that is a long list, Chairperson, of what the SGB must do, the department must do, which you must tick off, Chairperson.
Honestly.
Thank you. Sorry.
Yeah, Chair, if I can then jump in on the last question regarding the loans. So currently in the SASSA, it says that the permission of the MEC must be sought if a government, governing body, a governing body may not enter into a loan or overdraft agreement without the permission of the MEC. So that's the current law. It doesn't state exactly what what the loan amount is, and the current Bella bill does not affect that or change that. And the reason for this section is that why the permission of the MEC must be sought is that in the end of the day, if a school does not comply with the loan agreement or defaults on that loan agreement, then it is the department that would then be responsible for the payment of that particular loan, and that, as you may imagine, can then cause budgetary constraints, for a department that must now step in and fulfill the loan agreement. So there's no specific amount stated there, and it would be difficult, to determine, what would be a fair amount or a specific amount above, which the permission of the MEC must be sought. Now, in terms of the lease agreements, the clause says that the permission of the MEC must be sought if the lease agreement is more than 12 months. Because there is short-term leases that schools enter into where you don't want to, which may be a burden then for a school to obtain the permission of the MEC. For example, you may, in a certain school may hire out this hall, for example, maybe for a day, for a certain event. In a case like that, you don't want to burden the governing body to obtain the permission of the MEC for something like that. So this is really where the permission of the MEC for lease agreements must be sought is only in cases where there's a long-term lease that's longer than 12 months. Chair, I hope that answers that question. Thank you.
Thank you. I have one follow-up question, and then I see Member Christians also has his hand up. My follow-up question is regarding the closure of small and non-viable schools, where you mentioned the 135 in primary schools and less than 200 in high schools. And I'm just quickly thinking about my own constituency, Laingsburg, where we only have one primary school in the municipality and one high school. And then we have one primary school in Maatjiesfontein, and those primary school learners go to the high school in Toes River. But on a good day, one of the classes in Laingsburg might have up to 40, but it really doesn't get that high. It's usually an average of like 30 learners in a school. And in primary school, it might be also a little bit less. And if that is the case, you're essentially telling me that there'll be no school at all in my constituency of Laingsburg municipality. So I'm a little bit concerned about how that is going to affect farming communities. So I do think maybe we need to engage on this particular matter a little bit more. And then I saw Member Christians' hand. Member Christians.
Thank you, Chair. It's you almost covered me there, because I was thinking not so long ago there was also a big fight in the Oudtshoorn municipality about schools, and I think it was a good answer to say, listen, they must, if the community resist, you cannot proceed. But in the past, communities were very vocal about not closing of schools, and schools were still closed. Exactly for what you say, and we have the major problems when it comes to farming communities, and that is the biggest struggle in the Western Cape, where farming communities are very far apart from one another, and it's very small schools. And like you rightly said, now there's certain areas in farming communities that transport is going to be a huge problem, getting children there. So I just want to hear, and this is the question, if there is opposition to merging schools, and the department continues to say, listen, we're going to close down. The community says we are resisting that for X, Y, and Z. Now, in the past, I believe that the department, had the right to close a school because it's not viable. But our children is then left stranded. So I just want to know, so if the community do resist and say, listen, in Laingsburg, if we close this school, or in Oudtshoorn, on the farming community, close this school, it's going to be impractical for these children to attend that school because of the distance. And it means that many of our children then goes to boarding houses and see their families on a weekend. So just how do we get, if the community resists, is there then, mediation, and how do you come to a result at the end of the day, that the department says it's not viable, we only have 50 learners, but the community knows, it's not going to work, our children's going to drop out because of traveling arrangements, because of your boarding schools and all of that. So it's a major concern, and many of our children do drop out in these farming communities because of these issues. Just that, Chair, and maybe, Chair, just the other thing that I made a note of is when you ask about the loans, it can become very problematic because of maybe the sum amount. But it's also very dangerous if you look at the number of schools that we have. And say, for instance, out of the 1,500 odd schools that we have, people have just 1,000 rand. Just add that up, it works out to R1 million at the end of the day. So that also needs discussion and debate, because you work with a number of schools. And although the amount sounds very, very, very small, 1,000 rand, but what if, many school does that? Then you sit with R1 million, R1.5 million, and if it's written off, I'm just saying, but that is discussed another day. So they also, a person need to think through that, because you also don't want to pester the MEC with unnecessary burdens. And I think the gentleman said, maybe it's an administrative function, but it's still, a point of debate. Thank you, Chair.
Thank you so much, Mr. Ndlebe and Lucas. You can allocate it accordingly.
Chair, if I can maybe take a first bite, and then Mr. Ndlebe can come in. On this specific one, the first point that I want to make is that this is not the absolute case that if the learner numbers in the case of a primary school is 135 or fewer, then that school must be closed. The MEC has a discretion, and the word may is used there in 4A, that the MEC has that discretion then to close the school. So it's not the absolute that the close must be school that must be closed. It's a discretionary power. Now, there are lots of checks and balances in the bill to prevent abuse and to give the community a say in if that particular school should be closed. If you look at 4B, it says that the MEC may not act unless he or she has given, firstly, a written notice to the school and the parents that he or she intends to close the school. And then there must also be advertisement in newspapers circulating in an area. And there must also be, by way of other communication, the community must be informed that there is an intention to close the school. But very importantly, the MEC must consult with parents and learners of the school, and they must then be given an opportunity to make representations within a period of less than 30 days. And they can then, in those representations, give reasons why the school should not be closed. And if there are valid reasons, then and if MEC insists on closing the school, then that decision can be taken on review. Then also in terms of Roman numeral 4, there's obligation on the MEC to consider that representations. So there are lots of checks and balances also. As I've indicated, if the MEC insists on closing a school, for example, that may be the only school in the area, and if that school is closed, then it means that learners must go to the next town, or they must travel very far. You know, if there are valid reasons, as I indicated, that decision can then be taken under review. Thank you, Chair, and I give over to James.
Thank you, Chris. The way that I want to emphasize is that it's not merging and closing schools at all cost. There are schools that will never be closed for reasons that honorable members have cited. Is the only school, chairperson, primary school, only high school in the vicinity. You don't touch those schools, irrespective of how the numbers are. What you do, you then build mechanisms on how to support them better. Support them better means the MEC can overlook the issue of teacher-learner ratio and give them additional teachers beyond, because there's no other schools in that vicinity. But we're talking about schools here that are of walking distance. There are communities like that, 4 primary schools, one is not effective and all that. So this is where these things happen. And sometimes a school can be very small and the neighboring school, you can see it, but it's not crossable because of rivers. It's not crossable because of mountains. So you don't touch those schools, Chairperson. Thank you.
Thank you so much. And Member Christians just had a clarity question on the lease agreements that he mentioned that we have over 1,500 schools in our province. So even if the lease agreement amount is small, it seems like a heavy burden if every SGB is going to be sending those, even if it's to the HOD as an administrative function. It does seem like quite a heavy burden for every SGB to send every amount, every loan agreement, every single time to the department. If you can just clarify some of that information, please.
Yes, Chair. I think what, if I understand Mr. Christian's, if I understand his question or his comment correctly, these things can all add up. Even if it's a small amount, but if you have 1,000 rands spread over 2,000 schools, that's 2 million rand. And as I've indicated, at the end of the day, it is the department that will then be responsible if there's a default on that loan. But again, Chair, this bill is yours. If you feel that this is an area where there should be where the bill should specify that under a certain amount, there's no need to apply to the MEC. You're welcome to make that proposal. As I say, this is your bill. Yeah, thank you.
Thank you. Just to clarify, it actually is not our bill. The National Minister of Education has introduced this bill to National Parliament, and provinces, in terms of Section 76 of the Constitution, are giving our respective inputs and dealing with respective public participation. But I'm very glad at how open DBE is to amendments from provinces or proposed amendments from provinces. Colleagues,
sorry, Chair, what I meant is that you can make proposals for amendment, and you give your mandates. So yeah, there is still scope for amendments, and I know that is the minister's bill, but all I meant was there is scope for amendments, and if that can be a proposal that you can make, that there should be that particular amendment. Thank you.
Wonderful. Thank you so much. Colleagues, we're still on clauses 1 to 40. Are there any extra hands? Okay, I'll continue then. On clause 35, and I just apologies for the background noise. I'm next to a cafe with a generator. On clause 35, just dealing with the homeschooling, it mentions obviously that there needs to be home visits by officials. I'm just trying to understand. I mean, we don't even have enough teachers in our schools, but all of a sudden we now have enough officials to go to every single child who's being homeschooled. It doesn't make practical sense for me. If I could just get understanding why these home visits are needed, because it also then speaks about after grade 9 that no home visits are needed. And then also in terms of that particular clause 35, it speaks regarding, like, I mean, your explanation was the curriculum mustn't be inferior to the government curriculum. How will you determine whether a curriculum is inferior? I'm just really struggling with the wording of that clause and what exactly that is intended to achieve. And then my next question in that section is regarding clause 39, regarding the minister being able to make regulations on management of learner pregnancy. I know in last week's meeting you did indicate that you will forward us the draft document that the minister / DBE is working on so we can see. I am concerned at because this is a law. And as parliaments, we are legislators and we must legislate. It's one of our mandates. And essentially, what you're asking us to do is to legislate the power away in order for the minister to make a regulation on, when pregnant learners are essentially admitted and how does this work? When does someone come back? How do you deal with these situations? And I'm just concerned, one, substantively with how this will affect the admission of pregnant learners, because no learner, irrespective of their situation, should be denied basic education as an immediate realizable right. But also, I don't understand why, even if it is necessary to regulate, why does it need to be regulated in the regulations? Why can it not be in legislation? Because we are essentially legislatures and our responsibility is lawmaking. I see Member Christian's hand, and then I'll hand over to Mr. Ndlebe.
Thank you, Chair. Chair, I've got my sections and stuff mixed up here because you threw me out with your, doing that section first, but it's fine. It's 100%. So no problem.
No problem. You can continue.
Yeah, no problem. Thank you, Chair. Just, we had a lot of engagements, of course, with communities, and I just want to, the two sections that stands out for us and with the communities we engage was section 35 and section 39. It's a problem. When I spoke to the homeschoolers, people that done it in the past, and people that still pursuing to do homeschooling, the sense that I got from a lot of parents are that the department are trying to cripple homeschooling. The department are, these Ballable is really working against homeschooling. And, I've like I said, I've spoken, I don't want to get that sentiment, just speak about that sentiment. There's a big opposition when it comes to homeschoolers. And it's not, we must make it easier, although there must be accountability and all of that. But we must make it easier for homeschoolers to operate. And government is making it more difficult. So I just want to get the sense of what is reply there. And then, of course, section 39 is also, very problematic. And I'm not going to give all the details of what the people are saying, but, it's they're saying that the minister, with the regulations is actually also, I don't know, I don't want to use all the words, but at section 39 also there's a major problem where minister can make regulations pertaining, because they say that is just a subtle way you know, to drive agenda and of aborting babies, and I don't know what. There's a lot of speculation. So for our public hearings and stuff and those type of things, and you know, we'll discuss that further. But there's very unhappiness, a lot of unhappiness with Section 39, and very much unhappiness with Section 35, especially with the minister making, you know, regulations. And that has been the sentiments of many people. So we wanted to work, but there's a lot of problems in the ballot bill. So Chair, I didn't give a lot of details, but you know, engaging with people, because the ballot bill is the topic of discussion in many communities, and as public reps, we try to help and assist. And this will just give us more clarification, you know, taking it, because I mean, you know, people are saying, like I said, the Section 39 is a major problem, and Section 35, it's homeschoolers are feeling under pressure because they want to be enabled and not be disqualified for what they are doing. Thank you, Chair.
Thank you so much, Member Christians. And it is important that as members that we ask these questions of clarity. And because we as members are not going to be able to ask these questions when we go for public participation. The public participation stage is for the people of the public. So it's very important that we are able to exhaust our respective questions of clarity and really truly understand what the respective impact would be. Especially with Clause 39, I'm trying to understand what regulations would the minister make that's any different from laws and regulations within the health sector in South Africa already dealing with health matters such as pregnancy. But Mr. Ndlebe and Mr. Lucas, over to you, and then I'll open for the next round of questions.
Yeah, Chair, I will answer the question on the regulations. So currently the minister doesn't have any authority to make regulations on learner pregnancy. There has been a court case in the Constitutional Court regarding the rights of a learner who's pregnant. And in some cases you get that SGBs would expel a learner who is pregnant. So there is a need to provide protection for learners who is pregnant, and there's a lot of detail that needs to be put in those regulations, and that would be more more effective to put all of that in regulations. There currently is a policy on learner pregnancy, but as you know, a policy is not doesn't carry the weight of law, and there is a need to regulate or to put all of these issues in law, so that there is no abuse, and that that learners, pregnant learners, are protected, their rights are protected in terms of the Constitution and in terms of the law. The effective way of doing it is to put it in regulations. And putting it in regulations doesn't mean that there is no public engagement. As you know, the process of promulgating regulations involve public participation, consultation with stakeholders, and even those regulations may even then be tabled also in Parliament for the information. But I think there is a misconception on what these regulations are all about. These regulations is not about abortion. There is already provisions in the Children's Act regarding abortion, so it's got nothing to do with that. And I think that is quite a huge misconception. The minister cannot order in regulations a learner to abort a fetus. So it's got nothing to do with that. Thank you, Chair. I'll hand over the next question to James. Thank you.
Mr. Ndlebe? I think Mr. Ndlebe has fell off the meeting again. He might just be joining again. So what I'll do is I'll just open up for any follow-ups before I then move on to the next section, and then Mr. Ndlebe can deal with the question when he's back online. Just Mr. Lucas on the section 39 one. I think if you are saying there's a misconception as to what these regulations contain, then it's even that more important that that draft regulation is sent to us. Because perhaps the reason that there's a misconception as to what the minister can regulate and what the minister cannot regulate is because we have not been shown what it is exactly that the minister wants to regulate and do not want to regulate. Because if it only has to do with admission to schools and how we ensure that learners who are pregnant are not discriminated against, that is very different to health considerations. But if no clarity is given on that, then obviously members and persons of the public are going to make their own assumptions. So I think that just puts a higher obligation and responsibility and duty upon us as members to be able to see that draft document, because you are also essentially asking us as legislatures across provinces to legislate our power away to the minister. So we really have to be certain what exactly we are delegating away as a power. Member Christians?
No, Chair, I agree with you on that one. Just to add to that one, you know, and Mr. Lucas mentioned it. I mean, I'm not thumb sucking anything that I'm saying here. I'm saying that, and we don't have a problem with you know, children must be protected when they are pregnant. I mean, that is just how it is. You know, things happen, and that we must not take education away or restrict that child from further education. I'm 100% with that. But I just want to reiterate what the chair has said. If you speak to the public, if you speak on the ground, there's the people are saying this is giving the minister carte blanche when it comes to these regulations. And the abortion issue was mentioned. It's running right around every community, you know, and it's so important that we know. And you know, people don't have these answers because they don't have this opportunity now to ask the questions. I mean, that was done. But all that I'm saying is there's so much people on the ground that are saying this is giving the minister carte blanche. And you've mentioned about policies and all of those things. You know, policies is a good thing, and we. But now you want to have a regulation to force people to do X, Y, and Z. You know, you don't have the discretion anymore because it's regulated. And you know, policies, you know, people can look at the policy and apply it or not, if it's doable or not. But I want to agree with the chair that we interrogate this section 39 and see, you know, how we can, at least to the voter out there, to the people we represent, to bring some clarity. And that's why we're asking. I'm not asking questions because I'm asking questions because the ballot bill is a hot topic at the moment, and people are engaging because it's affecting their children, affecting them as parents. And so this section 39 is for many people a no-no, because it gives the minister carte blanche and they don't know what regulations is going to be made forward going forward, and it's very worrisome to the people in the state. Thank you, Chair.
Thank you so much. I just want to quickly check if Mr. Ndlebe is back on the meeting, and then I'll take Advocate Marstorp's hand. Liesel, sorry, I don't know your surname. I just see the word Liesel on the screen. Otherwise, I would have called you on your surname. Are you able to just get a hold of Mr. Ndlebe?
I will check for you again.
No problem. And then let me just take Advocate Marstorp's hand in the meantime.
Thank you, Chairperson. Chairperson, just in respect of the apparent alarm around clause 39, in particular a capital A, which I read that the minister will make regulations on the management of learner pregnancy. Now, I agree that we are the lawmakers, and I agree, Chairperson, with your input that we should guard against outsourcing our mandate into the realm of regulations. And I'm sure that my colleagues from the National Department, especially Mr. Ndlebe and my colleague Chris Lucas, will appreciate that the paucity of information regarding the management of learner pregnancy creates space for all manner of speculation, distrust, frustration, and anxiety. That, coupled with the fact that we cannot outsource our mandate as lawmakers, but also, and very, very fortunately, I'm not a politician, but we should also guard against spiraling communities, sometimes unfounded, conspiratorial speculation. We should guard against that too. There's responsibility on both sides. That being said, I would suggest, in order to not outsource our mandate, and in order to provide guidance to a minister in respect of the extent and scope and nature of regulations, it may be prudent to amend that first clause, A capital A, to read on the management, that the minister may make regulations on the management of learner pregnancy in respect of, one, ensuring the learner's physical and emotional well-being. Regulations may be made about that. Two, regulations in respect of ensuring and facilitating the learner's continued schooling. Three, regulations may be made in respect of, three, ensuring the involvement and continued support and engagement with a learner's parents or guardian. And four, regulations in respect of ensuring the school has the capacity and resources to facilitate a learner's well-being.
Yeah, no, I know the committee is dealing with that, but the person to...
So,
Colleagues, I'm just going to ask that everyone else is just muted while Advocate Marstorp is speaking. If you're not on the floor, if you can just keep yourself muted. Thank you. Advocate, you may continue.
So that was my last point in terms of guiding a minister in respect of which he or she may make regulations so that the anxiety raised by member Christians is addressed and the caveat raised by yourself, Chairperson, in respect of outsourcing our mandate is addressed. If we confine, if we contain the capacity of the minister's regulatory mandate to those things, then surely it, in my view, will appease much of the conspiracies flying about in the various constituencies. Thank you, Chair. That's for now.
Thank you so much. I think your comments are well welcomed, especially if we are able to just tighten up some of the provisions to ensure that we don't give blanket legislative authority away. I don't see Mr. Ndlebe online, and I just want to make sure that we will be able to get answers if I head over to the next section of clauses. Ms. Liesel, or is there someone else? Mr. Lucas, are you able to continue with clauses 41 to 54?
Yes, Chair, I'm still here. I think we may have lost Mr. Ndlebe.
Okay, no problem. What I'll do is I'll then continue, and anything else we will then put in writing. Colleagues are now opening up
Chair,
clauses 40. Oh, yes.
Before you
Member Christians?
go, Chair, just Mr. Lucas, I don't know. I've made the comments on the homeschooling. Can you just give us some comments on that questions that I asked about the homeschooling?
Yeah,
Mr. Lucas, are you able to assist?
Yeah, on the homeschooling, I think the intention here is just to protect the interest or to protect learners and parents and to ensure that that the standard of education that that a child will receive at home, that standard of education is not inferior to what is offered in public schools. That is also a constitutional imperative in terms of Section 29(3), although that section deals with, of the Constitution, although that section deals with independent schools, it would then also be applicable to a child that receives home education, that child should not receive education that's inferior to that of a child in a public or independent school. And a parent is free to offer any curriculum. There is no prescription on what curriculum should be followed. The parent doesn't need to follow the national curriculum that's offered in public schools and in some independent schools. So parent has a wide choice of what curriculum to follow. There's no prescription on that score. And then, as Mr. Ndlebe has indicated, the issue of home visit that has been that was changed in the or amended in the National Assembly. That's not required anymore. Thank you.
Mr. Lucas, I just want to check. How will it be determined if a curriculum is inferior to a government curriculum? I know Mr. Ndlebe mentioned that earlier, so I'm not sure if you might be able to assist us in that regard. But that was one of the matters that were indicated, that as long as the curriculum is not inferior to government curriculum, and I want to try and understand what exactly does that mean? How will we determine inferiority?
Yes, Chair. My understanding is that with curriculums, curriculum offerings are regulated by Umalusi. And if a curriculum is offered in a country, it must be accredited via Umalusi, who is the quality control organization. And they will determine whether that particular curriculum should be accredited and given status. And that is then also what is then required, because there are many various curriculums offered in independent schools. And all of those curriculums must then be accredited with Umalusi to obtain the status, because you can imagine that you can't just there need to be somebody to look at or to give a status to a curriculum. I hope I've answered the question, Chair.
Thank you so much. Any follow-ups or new questions on clauses 21 to 40? Okay, if none, I am now opening up clauses 41 to 54. Clauses 41 to 54. And with shock, I have none. Any other hands? Going once? Going twice? If not, then I just want to say thank you to the Department of Basic Education for going clause by clause through the bill with us. I know it's not always easy dealing with a very big bill, but this is really how one deals with legislation. You look at what the law currently is, you look at how you want the law amended, and then you look at the reasoning and impact. And it is important for members to be able to feel satisfied with the clarity and the questions and answers, so that when we go to the public, that all of the members' questions are at least exhausted. I know in last week's resolutions, we already resolved to have a separate session on costing, because there's been lots of questions on how this bill will be afforded, especially with the inclusion of grade R. So we will deal with that separately. There were also a number of other requests in terms of documentation that we eagerly await. And I just ask that members just please remain online so that I'm able to provide you with the feedback from the NCOP, and that we are able to just deal with our respective committee administration. But thank you so much to the department. We look forward to engaging you further on this respective topic. You may go ahead and be excused from the meeting to go ahead with your day-to-day activities.
Thank you.
Thank you, Chair, and goodbye.
Thank you. Goodbye. Members, in the meantime, please remember to stay online. Okay, let me just also open up my documents that I need to give you feedback on. Okay, let me just have a look here. Ms. Hassan Musa, are you also just able to assist me with putting up the NCOP program that they sent us? So on, I can't remember the date now, I think it was Tuesday evening at 9 o'clock. Am I correct, Ms. Hassan Musa? 9 o'clock Tuesday evening, the NCOP sent a notification that they were going to have a meeting on Wednesday morning at 9 o'clock regarding our request for extension on the timeline. Ms. Hassan Musa, can I just check that I got that timeline correct before I continue?
Yes, Chair, it was sent out at 16 minutes past 9 to inform the legislator of this meeting that will take place the next day.
Perfect. Okay, let me continue. One of the things that the NCOP meeting then considered was our letter for extension. I must admit it was quite odd for the NCOP to have a whole committee meeting to consider our letter for extension. I've never heard of something like that previously, but apparently there were other provinces who also requested extension so that they're able to meaningfully and be able to deal with the public participation process. The NCOP then returned and indicated that they would like us to submit our, let me just get this correct, our negotiating mandates by the 27th of March and our final mandates by 17 April. Now, with our committee resolution last week, where the department and the NCOP permanent delegate and members were present, we resolved that we were going to have 12 public hearings across the province. We also indicated that it's going to take us at least 2 to 3 weeks in order to send an advert out. We need to have an online template in order for people to be able to fill in, as well as templates if people don't want to send in their own, for example, written submission documents. There might be stakeholders that might be emailing us to do briefings to us as a committee, and we've already received one request, which I will deal with after this program. And when you take all of that into consideration, the travel, driving, and logistic time, but also having the public hearings at times in the afternoons and evenings that the respective stakeholders, learners, parents, and persons within the education sector are able to attend, that takes us well into mid-April with public hearings and possibility then with the 2 weeks of us putting our matrix together and getting all of our administration sorted, taking us essentially to the end of April with our own provincial program. Now, as you can see, this poses a problem, and given our resolutions that we made last week Friday, I've thus asked the speaker to just engage the NCOP to just, please just allow us to ensure that we are able to meaningfully, implement these resolutions and engage with the public, and that we're able to make sure that our logistics are in order, that our T's are crossed and our I's are dotted. And we have since not received reply yet. That specific letter went out yesterday, if I remember correctly, Ms. Hassan Musa?
Yes, Chair, at 7:30.
Yes, that was yesterday because the meeting was on Wednesday. So we are still awaiting reply on that. Now, the next step, members, would be that if the NCOP comes back to say, actually, no, we disagree, please, you need to finish by a certain deadline, my request to the committee is, what is the next step? Do we consider decreasing the amount of public hearings in order to assist with the timeline and risk not getting to enough people in the community? That's always a risk. Obviously, more public participation hearings always creates the opportunity to engage more stakeholders, engage more community members. So as a committee, we need to try and find a balance between the two. So I'm back to the members to ask members, what do you consider is that balance? What would you like us to do in this regard? I see Member Fry's hand and then Member Christian's hand.
Thank you, Chair. This is a tough one because this is a very important bill that requires as much public participation as possible. I don't understand why this bill is coming to us now, when only now, when it was tabled in 2022. So I think the pressure that is put on us is a little unfair, to be very honest with you, in my view. Because now we're forced to rush through this bill where we have to be diligent with regards to the public participation. That being said, I would be satisfied if we would reduce it by 12 to 10, and hopefully that would make a difference in the NCOP, and hopefully they would accede to us doing 10 public participation hearings, and that will mean that we would also get a vast majority of people, giving them the opportunity to make their input on the bill, as well as trying as far as possible to adhere to the timelines that has been given to us. Thank you, Chair.
Thank you so much. Member Christians?
Thank you, Chair. Yeah, tough one, but I just, from previous experience, when we did this, I'm talking about we actually reduced it. I think I'm just thinking about previous. We actually reduced it. Look, the big thing, Chair, is that we make the time frames. That is, we can't negotiate on that if we don't get feedback. So, but you also want public hearings. I think 10 is still too much. It's maybe too much stretched. I think between 6 and 8. You see, if you have it, the district municipalities, there's 5 of them. 1 or 2 in the metro should suffice. I'm just thinking, you'll get major points in the district municipalities. So there's 5 district municipalities, and then you maybe 1 or 2 in the metro, and that should maybe suffice. So between 6 and 8 should be fine. Thank you, Chair.
Much, Member Plato.
The Chairperson and members, thank you very much. First of all, I need to apologize to you, Chair, for being late this morning because of circumstances out of my control. I agree with Member Ferlin. It's a difficult time frame for us in our political season with the elections around the corner. The more public hearings it means as politicians, the more we are out of the loop in our wards, in our constituencies, to do canvassing and to lead the processes and that sort of thing. We need to bear that in mind very seriously. So I'm also for public hearings to the amount of less than 10 and that sort of thing. We can't just want to have meeting, but not engaging people in our constituencies in the running up to the elections. Thank you.
Chair, you're on mute.
Thank you so much. So I'm hearing more or less between 6 and 8 as an average to reduce to. Can you hear me now? Colleagues, are you able to hear me? Are you able to hear me? Anyone?
Trey, you're not audio.
Ms. Hassan Musa, are you able to hear me?
It's better now, Trey.
Yeah, I can hear you.
No problem. Advocate Master.
Chairperson, just a factual correction. Today is the 9th of February. The bill didn't come to us now. It came to us in November 2023. Thank you, Chairperson.
Thank you. No problem. Colleagues, is 6 to 8. I'm asking whether that is what we are agreeing to.
Yes, Chair, from my side, thank you.
Yeah, I guess so.
Okay, no problem. So perhaps we should try and stick to 7, which is then the average. Okay. Next up, I just need to quickly indicate that we got 1 request for expert briefing so far from the organization FETSAS. And I just would like to make sure that we just resolve that we are able to find a respective date for them to be able to brief the committee. We have not received further requests for expert briefing yet, but if we do get further requests, I will bring them to the committee. Members in order.
In order, Chair.
No problem.
In order, Chair.
Perfect. Then we have also received, I'm not too sure, Ms. Hassan Musa, did we get the written submission yet? Did we get the written submission yet from the Western Cape government from the Education Department?
Chair, they emailed me last week. I'll distribute it again and include it in the folder for the Bala Bill contents and make it available to all the members.
Perfect. I'm not sure if they want to take us through the submission. Could you perhaps just check with them? Because then we would have to schedule a separate session for that.
Sure, Chair. I'll make contact with the department and come back to the committee.
Perfect. And then we have already asked National Treasury just to do a briefing with us regarding the costing. We must just make sure that DBE is also present. Then, Ms. Hassan Musa, I think we only have one set of minutes then left to deal with.
Chair, can you see it?
I can, yes, thank you. Perfect. So this is last week Friday's meeting. You can just check your respective attendance and apologies. Okay, page 1. Are there any edits? Page 2. Any edits? Page 3. Any edits? If there are no edits, if I could get a mover for the minutes.
Chair, so move.
Thank you so much. If I could get a seconder for the minutes.
I second.
Thank you so much. The minutes are so adopted. Ms. Hassan Musa, I just want to check if I've remembered everything.
Yes, Chair, everything is covered. We will now make provision for the 7 public hearings as per the request, the recommendation of the committee.
Perfect. Thank you so much. And in that regard, I hope everyone have a wonderful Friday going forward. Thank you so much for being on the meeting and for our robust discussion. I hope you have a lovely day. The meeting is adjourned.
Thank you,
Bye-bye.
guys.
Thank you.
Thank you,
Thank
Chair.
you. Thank you, Chair.